all of us here now. All right, before we go to the answers of the three issues that I want us to go to page 8, but actually we started page 8, but I think the heading is at page 8, but we go to page 9. The other one is it's an article by O'Regan and Cameron J. Not that one, on recusal, but not the question. It's headed recusal. Yeah, on page 9. Now, what has happened is, as a judiciary, we also came together, crafted a document called the Guidelines for Ethical Judicial Conduct in Namibia, which all of us had said an input into. It's still currently in the phase of development because there's an issue with regards to gifts that we are trying to deal with. Now, in chapter 2 of the Guidelines for Ethical Judicial Conduct in Namibia, there are guidelines. Now, in those guidelines, it is stated that a judge shall recuse himself or herself from participating in any proceedings in which the judge is unable to decide the matter impartially or in which there will be a reasonable apprehension of bias in the mind of a reasonable observer. Now, take note that there will be a reasonable apprehension of bias in the mind of a reasonable observer. The judge has actual bias or prejudice concerning a party or personal knowledge of disputed evidentiary facts concerning the proceedings. The judge previously served as a legal practitioner or representative or was a material witness in the matter. Or there is a conflict of interest, such as where the judge, a member of the judge's family, a close friend or associate, has an economic or any other interest that will substantially affect the outcome of the case. Or there is a personal relationship or a personal animosity towards a party, is also a compelling reason for recusal. Now, then when we go to page 10, those are the guidelines. Now, when we go to page 10, now keep this in mind and keep it with the 7 questions that I have raised. The legal principles governing the recusal of a judicial officer. There are 2 circumstances in which a judge must, actually I must say a judicial officer. I don't know why I'm referring to judge here. It must be in which a judicial officer must recuse himself or herself. The first is whether the judicial officer is actually biased or has a clear conflict. Where there is bias or there is a clear conflict, like as I said, your brother, your sister, your business associate is involved. Whether you want it or not, they'll be biased. They'll be biased one way or the other. So in those circumstances, there is an obligation for you to abstain from presiding over such a matter. The second is where a reasonable person in possession of the facts would harbor a reasonable apprehension that the judge will be biased. Actually, the law on recusal revolves around those 2 principles. Where the judicial officer is biased, they must recuse themselves. Now, if we take the first question that we had, the first one. Yes. Okay, let's take the first one first. When you are in a romantic relationship, will you be able? Huh? But it's the prosecutor, it's not his or her case. She's just presenting a case, or he is presenting a case. Yes, you know, it's so interesting. Example, Judge Mainga. Judge Mainga has refused to sit on any case where Inonge is involved. He has refused. He actually doesn't sit. When Inonge was at the time also the legal advisor of the Motor Vehicle Accidents Fund. Judge Mainga also refused, because I did a lot of cases involving, because I was the external legal, Inonge is Judge Mainga's daughter. So he would not sit on any case where the MVA is also involved. He says, the person who's there is my daughter. Now, even if we have never discussed the matter, in the eyes of a reasonable observer, they will form the impression that whatever the outcome, I may have had an influence, or she may have an influence. So he refused to sit on any of those cases.
Before we proceed,
yes.
In the eyes of the reasonable observer, the example that she gave,
yeah.
prosecutor, interpreter, magistrate driving together, does that mean I must recuse myself?
Yes, that's why I started with. That's why I started with it. That there are two basic principles. The question that you will ask yourself is, what will a reasonable person, with all the facts and information, you understand? Even if you don't discuss, you form a very close relationship. You understand? So a reasonable observer, informed observer, will definitely form a reasonable suspicion that the magistrate and the prosecutor, and it becomes even worse when you drive with the legal practitioners involved. You see, there is no actual bias, but a reasonable person, reasonably informed, will they come, if the reasonable person, reasonably informed, will come to the conclusion that the judge is likely to be biased. It's not the suspicion, but the likelihood. Now, the prosecutor and the magistrate, for you to prevent that appearance of bias, avoid to drive together. Now, if you recuse yourself, there's only one prosecutor, there's only one magistrate. If you recuse, who will do the trial? Let the prosecutor, you see, especially now, okay, previously we were all public servants. We are no longer public servants. After Mostert, we are not public servants. Yes, we are a part of, there are three arms of government: the judiciary, the executive, and the legislature. So you need to be independent, and that independence must not only be done, it must be seen to be done. So the issue of the magistrate and the prosecutor driving together will, in my view, I don't know, somebody else can have a different view, but in my view, even a reasonably informed person will form the view that the magistrate is likely to be biased in favor of the prosecutor. Those whom I have taken through administrative law, I recall taking a caption from this case, hanging it up, and I asked them to discuss it. Now, Pinochet's case is simply, the facts of this are simply as follows. Pinochet was the president of Chile. That's prior to 1999. He was one of the best renowned dictators. He has killed so many people, he has done so many. So Pinochet fell sick. When he fell sick, he came to England for medical treatment. And once in England, people started brought application for him to be arrested and to be extradited to Chile to face so-called crimes and prosecution. He managed to go to Spain to avoid, because Spain then didn't have an extradition treaty. So the whole issue of Pinochet then came up for trial. Now, I think one of the judges who said on his question whether he has to be extradited or not, the judges was either him or his wife was involved with Amnesty International. Now, imagine Amnesty International campaign for the freedom of people, the freedom of political detainees, human rights, and all those issues. So one of the judges, either himself or his wife, was involved with Amnesty International. Now, the judge sat on the case and ordered the extradition of Pinochet. Then it became, after the decision was made that Pinochet must be extradited, it came to his attention and his legal practitioner's knowledge that one of the judges who has sat there was either a patron with Amnesty International or his wife. So they then appealed to the House of Lords on the basis that that judge ought not to have sat, because in the eyes of a reasonable person, any reasonable person well-informed will form the conclusion that the judge will advance the cost of Amnesty International to have those people who have abused people's human rights to be extradited and to face prosecution. The House of Lords, in a very crisp statement, said, appearance matters as much as reality. The appearance is as much as important as the reality. Where there is an appearance that there is a likelihood of bias, and the House of Lords found that the judge ought not to have sat on the matter and reverse the whole extradition issue, simply because of the appearance. Appearance is as important as the reality is. That's what so what you are saying is there are two circumstances. Is when you are actually biased, when there's a conflict of interest. As I said, like where it's my brother, my wife, my sister, where they are involved. There's a clear cut, straight away bias or a conflict of interest. There you recuse yourself. The second instance where you recuse yourself is what happens in the eyes of a reasonably informed person. Right? Now, what case, we had case number 1, case number 2. What is the second case all about, the second question? The second question is about the magistrate in Opuwo. Yes, Muchali spoke of upholding. He was going to uphold it because of the mental reference, but I was not going to go there. Now, remember what we said. As a presiding officer, you must be impartial. Right? Now, one of the essential requirements of impartiality if we go to page 8, under requirements of impartiality, I have given you a case of the United Kingdom where the European Court of Human Rights has said that there are two aspects to the requirement of impartiality. First, the tribunal must be subjectively impartial. It is no member of the tribunal should have any personal prejudice or bias, Personal impartiality is to be presumed unless there is evidence to the contrary. Now, let's take the facts. This is a guy who's arrested. The matter is postponed because why the lawyer doesn't come. And this actually what I did is, this affects from all these seven questions. I took decided cases and just changed the names of those cases. These are actually cases that happen. So a guy comes, he's arrested, the lawyer, for one or other reason, there's no explanation, doesn't turn up. The magistrate makes the comments that he or she has made. That, after the explanation, you go brass. You understand? So now I see why you are a lawyer. It's because your head is making noise. That's why you are. What does that tell you? Will this guy get a fair and impartial hearing from this judicial officer? The guy has already made up his mind on the guilt, and he confirms that actually. If you go, there is that statement that he made immediately after, and then when you go and read one of the reasons, he says, you see, he actually confirms it in his ruling that your lawyer kept away because he thought there's something wrong with you. Your head is. So this guy never received a fair hearing. The magistrate was prejudiced. He had a personal bias towards this. You must disabuse yourself of all those issues. If the magistrate hadn't made that statement, actually that conviction and sentence was set aside, and the guy walked free.
So if he did not make that statement,
You see, what you are saying is impartially, it is presumed, because of the training, because of the experience, that a judicial officer will be impartial. There's that presumption. Now, if I want to dislodge that presumption, I need to bring evidence to show that although there's that presumption, this judicial officer wasn't. Now, here the record, all these issues were on the record. It appeared on the record that the lawyer came, and then the magistrate entered that the lawyer is absent and the matter is postponed. On the date to which the matter was postponed, the lawyer didn't turn up, and this guy said, no, I'm prepared to defend myself. And then he was asked to give a complete explanation of the defense. And then that's what he said, what is there. So after that statement, the magistrate then makes a comment. Now it tells why your lawyer is not there. You see, so that's an example. This is an example of that this person, the magistrate has already made up his or her mind on the state of mind or on the state of the accused person. And once you have made up your mind on the state of an accused person, let me give you this example. It's a case, this case is actually, you'll have to look it up for yourself. It's a case that has recently been decided by the Supreme Court. An accused person is brought to court. On the first appearance, there's a pre-trial hearing in the High Court. He comes, he's in civilian clothes. At the first hearing, he's in civilian clothes. The trial continues. On the third occasion, okay, I see Ms. Lorraine is laughing. It's from her jurisdiction. Yes. On the next occasion, the judges says to the correctional officer, the guy comes to court, but he's in prison garbs. The judge just says to the correctional services authorities, please don't bring that guy. Next time you bring the prisoners, let them not have prison garbs. Because when he's in prison gaps, it's an indication that he's already a convicted criminal. Now, so what it does is when you are sitting with a convicted criminal, as a human being, you tend to think that he is a person of bad character. So notwithstanding the fact that the judge made this comment and told the correctional services officers not to bring the person in prison gaps, they continue to do that. They brought the person in prison gaps. She then asked the legal practitioners to address her in the circumstances of those cases, whether she must recuse herself or not. She recused herself. But actually, before she recused herself, she asked the legal practitioners, the lawyer representing the accused and the state prosecutor. What do you think? What is the stance of the lawyer defending the accused? You see, you won't believe me. Lawyers are funny. And lawyers have studied us also, as I was saying. No, they knew the judge is a very fair-minded judge. They knew the judge is a fair-minded judge and has got some sympathy for people. So they wouldn't push for the recusal. They said they'll abide. But yes, initially they said they'll abide by the decision of the judge, whether they recuse themselves or not. So the judge then ended up recusing, but the state didn't want the judge to recuse herself. They pushed for the judge to sit. So she then heard arguments from both sides, and she decided to recuse herself. The state appealed. Velikoshi, you have read the judgment.
Yes.
Now, why did the court, the Supreme Court, what is the ratio in that decision?
Well, I didn't read the whole judgment.
Yes. Exactly.
The summary, I read the summary.
Yes. You know, we are doing, those are the mistakes we do as legal practitioners. And I experience this on a daily basis. A person reads the head, you know, I was so angry. I was angered one day because I had read the case. A lawyer appears and cites the case. He tells me. So I said, okay, what are the facts of that case? He tells me the facts. So I asked him the same question I asked Mr. Velikoshi. What is the ratio of that decision? My Lord, I haven't read the whole decision. How do you cite? You don't cite a case you haven't read. And you have to cite the case because of the ratio. Now, yes. Yeah. Now, in the case is all I know. It's cited as state versus SH. It's S and SH. I think the judgment was delivered on the 14th of June by the Supreme Court, 14th June, 2017. July.
But it was later.
No, it's this year.
Yeah, this year, but it's not June.
Okay, no, I'll.
After June.
No, look at the footnote. Footnote 5. Huh? Yes. Why the Supreme Court here in this matter accepted as a matter of principle that yes, when an accused person appears before court in prison gaps, it has an impact on the presiding judicial officer that this is a person who has been previously convicted. So it may sway and may render the trial unfair because the judicial officer may have formed an opinion on the character of the person standing in front of him. But in this matter, the facts where the Supreme Court decided differently is that, one, he was facing in the matter in which he stood accused before the judge. He was charged with housebreaking, with intent to steal and theft. He was charged with, and he also faced 2 charges of rape. Those are the charges that he was facing. The charges of which he was convicted were never revealed to the judge. Secondly, when the judge invited the legal practitioners to address the judge on the recusal aspect, the accused himself was also asked to address the court on the recusal, and he decided to remain silent. Do you understand? So the Supreme Court found that, you see, because we don't know, because the DCJ who delivered this judgment said, this person, the conviction which he faced, may also as well have been a conviction for failing to pay maintenance. It may have been a conviction, a traffic fine, you understand? So if you don't know what the conviction is all about, but if you knew that he was, for example, convicted because of rape or bribery or housebreaking, that will definitely have an impact on your view and perception on him. But in this case, his previous convictions were not revealed. Secondly, the accused person himself did not indicate. So remember the test. A reasonable person informed with reasonable information. So this person didn't have information on, you understand, he didn't form a view on whether the judge, he formed the apprehension that the judge is likely to be biased. And on those 2 grounds, the Supreme Court set aside the decision to recuse and found that the recusal was wrong. The judge should proceed with hearing the case. You see, the court took into account 2 critical issues. The critical issues that the court took into account is that the convictions, or the convictions, the charges on which the accused person was convicted and the sentence he was serving was never revealed. So it could as well have been convictions on traffic ticket or failure to pay maintenance. So even if a person fails to pay maintenance, how does that impact on his character when he's facing a charge of rape or housebreaking? They are unrelated. But as the Supreme Court says, as a general proposition, it is true that when you sit and the person who's appearing in front of you, you know is a convicted criminal, it tends to influence you and diminishes that person's possibility of getting a fair trial. But those are not the only issue. You go deeper and you look at it to all the facts of the case. And here they found that, the Supreme Court found that because the convictions were not revealed, the other issue was the person himself was given an opportunity to comment and to address the court on his perception, whether does he feel that he will get a fair hearing or not. He chose not to speak on that. So the Supreme Court said, on what basis does the court then come onto there is no evidence that a reasonably fair-minded person, reasonably informed, because the judge made it quite clear in court, in open court, that when you bring a convicted person before me in prison gaps, that tends to, it may influence. So that information it's a reasonable person, he has all the information, and he needs to make a decision. He didn't make a decision. So if he didn't have the information, it's a different ballgame altogether. But he had the information. He didn't make use of the information. So the court found that there was no basis for the judge to recuse her because it was not based on evidence. Remember, the elements is that there must be actual bias. In this case, the judge never said she's biased. She didn't say she's biased. So that requirement wasn't fulfilled. She never found that she is biased towards him because he's and she couldn't, on what basis would she say she is biased? The second requirement is a reasonable person with reasonable information. Now, this person was given the information. He chose not to make any statement what he perceives, whether he will. So both the requirements were not fulfilled. Now, with those two requirements, let's go back to question 4. So how do we test question 4? Is it question 4? The one of the black boy. Yes. Yes.
Don't you test, I think we should test on the second leg.
Yes.
A reasonable person in possession of all the facts. Have a reasonable
Yes.
ability to judge his bias.
Yes. Or maybe biased.
Maybe bias.
Remember, it's not that he is biased.
Maybe.
Is that the likelihood. Remember, if you read the earlier cases, they used to make a distinction between suspicion. I suspect that you will be biased. I suspect it's suspicion. The other one is a likelihood. There is a likelihood that he or she will be biased. Now, the courts have not adopted the reasonable. They are saying the reasonable suspicion of test is more exacting because you need to place facts before court on which the suspicion is based. Wherever the reasonable likelihood, all that I need to do is, like in this case, assume a person is convicted of rape, appears to be in front of you, charged with rape. What will you really give him the benefit of doubt? Eh? A person who comes before you, he's charged with rape. Yeah, he has a previous conviction for rape, and he appears before you again for rape. And you are aware as a presiding officer, this guy has previously been convicted of rape. The likelihood of giving that guy a fair hearing, in my view, is 20%. And actually 20% is even high. I put it at 10%. The question number 4. Let's discuss these two questions together. Question number 4. My son was killed in 1989. He was killed in it's publicized, it's known, it's my son. It's my son. It's known publicly widely by white officers. A white officer comes charged with murder in front of me. Can I continue with the trial of this white officer? The facts of this case is actually also a reported case, but this is a South African case. I think it's a case of State versus Scatchell or something like that. It's Scatchell or something like that. It's reported, I think, in the 1999 law reports. The issue, whether you continue or not, is not the issue here. As a judicial officer, remember, you have been appointed in terms of the Constitution to preside over all cases. And you have an obligation to sit on all matters where you are not conflicted. But Surya actually captured this whole issue very correctly. Surita, is it Surya or Surita? Yeah. The whole issue is The same with this person, what I will do and what any judicial officer must do is I must disclose to the parties that are appearing before me. My son was killed in similar circumstances. What will a reasonable person possessed of all the reasonable information, will he form a reasonable likelihood that I'll be biased? If the answer is in the affirmative, I must recuse myself. If the answer is in the negative, I must sit. So there is no straight way. You see, all these issues, I can never give you a direct answer that sit or do not sit. You ask yourself those two questions. First, is the actual bias. Now, actual bias in 90% of the cases, it's only a corrupt person and a dishonest person who will sit in a case in which he or she is conflicted. It's only a corrupt and a dishonest person who will sit in a case because you want to influence the outcome of that specific decision. But 90% of the cases that we deal with on recusal is more the question of the reasonable information and the reasonable likelihood of bias. So, Mulima, the answer to your question is simple. What I will do, if this person comes to me, I'll inform them that I've read about your conviction, I've taken note of it. Now you are faced, and it's the same charges. Are you comfortable? Do you think I'll be able to impartially and give you a fair opportunity? If they are, then you proceed. But if they say no, you see, this is a problem. At times we express ourselves that criminals must be what a person. You see, you form an opinion. A person convicted. So once you have expressed your opinion on a specific issue, you will be disqualified. So in the case that we have, the judge never disclosed to the parties that his son was once killed in police custody. He went ahead, and the Supreme Court there said, even if the judge was not biased, what is it that a reasonable person with all the information will do? He will form the view that the judge is likely to be biased. And because the judge is likely to be biased, he should not have presided over. So this convicted police officer, the conviction was quashed, the sentence set aside, the matter was referred back for trial before another judge. As a judicial officer, it's not that you must recuse yourself. Just, you see, when I alert the parties appearing before me that I have this information, I know about it. You understand? So they must then make an informed decision. Do they trust me in my training and my experience that I'll give him a fair opportunity to be heard or not? If they don't trust me, they'll ask for my recusal. And on the basis of that, I think I'll recuse myself. Your life experience has told you something, and you are carrying that life experience into the. But remember, every case must be. What is the behavior of these accused before you? What are the facts? So forget what life has taught you. Take this case on its own and evaluate it. Now, it's unlikely that all the judges, there are judges, one newspaper you will have read, one newspaper you will have missed. It's unlikely. But all that I'm saying, what is important is that you must reveal the information and the knowledge that you have to the parties that are appearing before you, so that they can make a decision whether they will proceed before you or not. But when you keep it back from them, and it later becomes known that they had that in knowledge, the question then comes, why is it that judge didn't reveal to us that he has this information? Because he wanted to achieve a given outcome. You see, hey.
Now you are aware of his previous.
Yeah, no, I convicted him On 2 previous, he comes on the first one is theft. Second one is theft. He's coming for the third one, theft. Am I likely to believe in his innocence and the explanation that he's going to give me? Am I? Eh? No. Yes, each case must be dealt on its own. But all I'm asking, you are a human being. I'm a human being. Okay, the first time I found you guilty. The second time I give you the benefit of the doubt. The third time, same charge, same offenses, same magistrate, same prosecutor. No, you see, one thing I must say, with the review, I am never always confident of endorsing reviews. I am not confident of the, unless there is a judgment written. Because when I'm looking at a review, all that I'm looking at, for example, all those issues will not be reflected and I look at the review confirms me, was the process in conviction fair? So I look at, was he asked to plea? Were his rights explained? Did the magistrate follow? But what you are saying, for example, that this guy had appeared before you previously, you convicted him of the same offense, he appeared before you on the second time, those aspects are not before me when I'm doing review. So I will not, so therefore I will endorse, if I say the current case that came before me, you followed all the procedures, it was fair, I'll say the process was in accordance with law and it's fair, it can go on. But in reality, this person, would a reasonable person possessed with all the information form a reasonable likelihood that you will give this guy a fair hearing? I doubt. I don't know, but I doubt, personally. In terms of our jurisdiction, you can take previous conviction into consideration when you are sentencing. But before trial commences, for purposes of conviction, you cannot, the law prohibits previous conviction to be taken into consideration.
Yes.
Yeah, but he has previous conviction, but it will tell us that he had previous, but the previous conviction doesn't tell us who convicted him and on what he was convicted. I think, no, the what is there. No, the what is there. Yeah, but who convicted him and when would not appear. It's just that he had previous conviction on theft, previous conviction of theft. But when one person appears before the same magistrate on 3 different occasions, that he appeared before her on all the 3 occasions, that will never be clear on the review record. If, for example, at the commencement of the trial, like, what's her name again? Jorina. At the commencement of the trial, when you know that this accused person has appeared before me, not only once, but twice, this is a 3rd time, and for the same offense that he's facing now, you have an obligation to tell him that you have appeared before me. And I'm going to raise, are you confident that I sit on your matter? He must then address you and put facts before you. To proceed as if nothing has happened. If it comes and it's appealed, I am almost convinced that conviction will be set aside. But then the previous interaction has had no bearing on you. Exactly. You see, but where you are aware, I'm talking of where you are aware. Where you are aware that this person appeared before you once, twice, you are aware. At the beginning of the trial, it will not be fair for you to proceed with the trial without having informed him. What I'm saying is, when you know and you are aware, put those fair. You see, the unfortunate part is that most of the accused persons are unrepresented. So he will not be able to articulate his stance and position. But what I'm saying is, when you are aware at the beginning of the trial, put those facts to the party that is appearing Let them take an that I am comfortable for you to sit. You know, but litigants are very interesting. Charlotte will know. I said on the Nashinge versus the Swapo Youth League party matter, I've had my interactions with them before I became a legal practitioner. So when the case was allocated to me, I called the lawyers. I said, yes, you guys know I was a member of the party. But ever since I've been appointed, I've resigned and I don't participate in party politics. Are you confident that I sit on this dispute of you guys? And some of them I was on the Electoral Commission. Some were insulting me at the Electoral Commission level. So on those bases, I called them into chambers, the legal practitioners, and said, here's the position. Are you confident with me sitting? They all said, yes, we are confident. When the judgment came out, I was a barbaric. No, it's true. No, you are barbaric. Your brother is running for Swapo Central Committee. All this comes out. Yeah, you see, imagine now if you had not engaged them and involved and discussed with them. As I said, state versus SNH, you are given an opportunity because the test for recusal is a reasonable person in possession of all the information. Will they form a reasonable likelihood? Will they form the opinion that the judge is reasonable? If you don't say anything, on what basis can it be argued that you will form a reasonable opinion, an opinion that the judicial officer is likely to be not to be impartial?
Well, the accused can say, who am I to tell the magistrate that...
No, you see what? One thing that we must keep in mind is, when I say I explain your rights to you, it's useless for me to say you have a right to legal representation. It's useless. So I have a right of legal representation, so what? So what I normally do, I say especially to the unrepresented persons, you see, you are right to, and I've used this example many a times in court. I said to to parties that come, just tell me one day where you have walked along Independence Avenue and you have come across people extracting each other's teeth. Just one. Have you seen any person, we are two there, I'm extracting your teeth, you are extracting mine. Have you seen that? You have, because why? I'm not a professional dentist to extract a teeth from you. The same happens with legal representation. And remember, it's not just for you to come and tell me your version. The way in which your version comes to me has procedures. And there are issues that are admissible and that are inadmissible. And those require legal. It's for that purpose that you have the right to legal representation. So you explain to the person, they know what the content of the right to legal representation is. But just telling me, yes, you see, but just saying that I know of your convictions, it's not really informing that person of why you are telling him that info. You need to tell him the information and explain to him why you are giving him that information so that he or she makes an informed decision, especially when they are not legally represented. When they are legally represented, I have no problem. The question that you face, in all these cases, the question that you face is simple. When I'm sitting here, am I open and susceptible to persuasion? That's the question. If you are not open and susceptible to persuasion, you are not going to afford this person a fair hearing. So that is, you see, even if I feel that it's not right, the question I must, at the end of the day, ask myself is, am I going to be open to persuasion? Am I going to be open to persuasion? If I'm not going to be open to persuasion and argument, then you can't sit on that case because you have already made up your mind. It's just like I said today. It will take an issue for you to tell me that a teacher and a student can be involved in a romantic relationship and it's normal. It will take Jesus Christ. So as soon as I sit in a case like that, I'll recuse myself because that person, whatever they face, will never get a fair opportunity, a fair hearing from me. They won't. For the purpose of the state, yes. You see, then what they can do is they go and look at the issues and come back and say, yes, there was a basis. The evidence pointed to an acquittal when we are confident for you to continue. We are human beings. We have our, society forms you. It does. But when, you see, in cases, I have had so many cases, in cases where I am just not comfortable, I don't even ask themselves. I don't ask the parties. I tell them, I don't think I'll be able to deal with the matter, and therefore I recuse myself. Do you understand? And I'll give you an example. There's a case involving Namport. It was a case involving Namport. Now, one of the people who came to me with a brown envelope is an employee of Namport. So when the case came to me, I called the parties in. I never revealed why, but all I simply said is, I am not, you see, I don't think I'll be able to deal with your case, and I am recusing myself in this matter. You see, because why? I was sitting there and saying to myself, this is a person who once approached you to sway the outcome of a hearing in their favor. Now comes another case before you. Do you see it as if nothing has happened? If I found in their favor a reasonable person, yes, in the position handed with all the information, will they form a reasonable, an opinion that I will not, the likelihood of bias will rise? And I said, yes. Simply on that basis, I didn't even ask them. I told them I'm not going to sit. Because in my mind, myself, I knew I was, and the other thing is, you would find ways to defeat them, to try and prove that you are not susceptible to bribes and corruption. Do you understand? So you are not really giving this person a fair opportunity to be heard. You are placing the bar a little bit higher than him. So on that basis, I recuse myself. I send the matter to other judges to hear it.
You recused yourself out of your own volition.
Yes.
Between you and the party that had approached you, the party that had approached you knew the reason you had recused yourself.
I don't know. Do you see? Because he did not approach me in this matter. It's about 4 years ago that they approached me. Yes. Let me tell you, legal practitioners will never approach them yourself. This I can tell you. Legal practice, even when dockets are stolen, I am a legal practitioner. I was a legal practitioner. When dockets are stolen, it's the legal practitioners. I'm sorry to say this, but this is the truth. They either will know or they will have initiated it. So a legal practitioner will never do it himself. That you can forget.
But he knows.
Yes, he either knows or he sends somebody. You see, what I say is, the explanation that I'm going to give is that I do not think I'll be able to afford you a fair hearing, full stop. I will not be able to afford you a fair hearing.
Basis? Oh, so
Yes.
and that's a sufficient reason.
If as a remember, Article 12 says every person is entitled to a fair hearing to a hearing, not to a fair hearing, by an impartial and an independent court. Whether I sit alone or whether we sit three, whether you sit alone or you sit three, you are a court when you are properly constituted. Now, if I know this is what I'm saying, if I know in my mind, I am not going to give you a fair hearing, I am not going to sit in that matter.
So, Judge, are you saying in some cases you can declare, in some you don't have to?
No, I declare.
Yeah, but now my issue is the basis. I mean,
The basis is what I'm. You see, the basis is simple. I'm not going to give you. Okay, it has never. They never asked me. But if they were going to ask me, I was going to reveal.
The basis of
yes.
you saying that you would not be able to provide.
Exactly.
A fair
Yeah, I'll say it. Yes. The basis is that one of the parties to this hearing have attempted to influence me improperly. Not in this case, but in a previous matter, to find in their favor. Now, if you have attempted, how do you attempt to influence a judge in one matter, and then the next time you want to stand before him? It doesn't sit. It's just not right.
So in other words, you can never hear matters represented by that party ever.
But involving that party ever, I won't. Involving that party. It's not a legal, the person who came to me is not a legal person. It's a person who's employed, and he's employed in a high position in that institution. You understand? So this institution is involved in the case before me. I just said, I don't think I'll give you a fair hearing, and therefore I'm going to recuse myself and send the matter to somebody else to deal with it. The crux of it is, will you remember the constitutional issue? As I said, the persons are entitled to a fair hearing. When I know nothing and the playing field is level, good. But when the playing field is no longer level, I am not going to sit. Then there is no fair hearing. This is where we come in, where I said, what is it? The Satchwell case, the judge whose son, it's a high court. This police officer was tried in a high court. He was tried in a high court. But simply because the judge did not disclose to the parties that his son was killed in similar circumstances, the Supreme Court of Appeal found that in those circumstances, the judge had an obligation to disclose it to the other parties. And if they had chosen, so the court did not even go, and you don't go into look into was the judge biased, was the irregularity. No, you look at the appearance. Appearance is just as important as the substance. Pinochet. Appearance matters as much as the substance. So if there is an appearance on a person possessed of all the information, that there is a real likelihood that the judge will be biased, there's disqualification. As soon as there's an appearance of bias, there's no proper conviction again. You understand? Because the appearance taints the correctness.
Do you then send him back to be retried? Or
Yes. Yes. As I'm saying,
I'm just thinking,
Yeah.
there's no justice there. If a person is
No, you don't. You see, the only issue that I'm aware of, look, State versus Manuma. Is it State versus Manuma? Munuma. Do we know the facts of State versus Munuma? Huh? Okay, the facts of State versus Munuma are basically 1999. We know what happened in the Zambezi region. Now, Munuma and others were also treason accused. So they were arrested and brought before the High Court for trial. So Munuma, there are nine. State versus Munuma. Munuma and the other 8 were then arrested. They were brought before the High Court. No, the whole thing continued for quite. They were tried by a judge, the late Justice Manyarara. Now, before Justice Manyarara, they raised the issue that the High Court did not have jurisdiction to try them. Because after the events, because after the events that happened in the Zambezi, in Katima Mulilo, they left the country for Botswana, and they were abducted in Botswana and brought back to Namibia. So that's an alibi, that's a defense of alibi. You understand? So and on that basis, they said they never came back voluntarily to Namibia, but they were abducted and brought to Namibia. So they challenged the jurisdiction of the High Court on that basis. Manyarara did not believe their alibi. So he rejected the jurisdiction issue. He then rejected it. The accused persons appealed. They appealed simply on the jurisdiction question. They appealed to the Supreme Court. The Supreme Court found that the High Court had jurisdiction, right? And referred the matter back to the High Court for the High Court to continue with the trial. The trial came and continued before Justice Manyarara himself. He continued with the trial and found them guilty and sentenced them. So they appealed again. Now on this time, the appeal was, actually they initially asked for Justice Manyarara to recuse himself. He refused to recuse, he continued, he tried them and sentenced them. They appealed. The Supreme Court found that Justice Manyarara, when he found them, when he dismissed their defense of alibi, he has already formed an opinion on their guilt or otherwise, and he should have recused himself on the second. You see, because he has formed an opinion, he has disbelieved them, so he should have recused himself. And because he did not, you see, the trial was fair. You know, these guys were singing, disrupting, doing all sorts of things in the High Court. The Supreme Court did not go into the correctness of the conviction. All that it says is, initially when these guys came with a defense of alibi, you disbelieve them. And because you have disbelieved them, you understand? You have already formed an opinion. You ought to have recused yourself and not sat on the matter. So the convictions were quashed. And the matter is now, it's still going on. They are now before Justice Unengu. All a new trial afresh. So when you set aside the trial on the basis of those technicality, you don't acquit. It's an irregular. You only acquit where you go into the merits. If you have not entertained the merits, you don't acquit. You set aside the proceedings as irregular because the person is not entitled to a correct decision, or he's entitled to a fair hearing. Even if the outcome is not correct, as long as it was fair. No, that was, remember, that was initial on the alibi defense in the jurisdiction, because the initial...
Was an alibi in jurisdiction?
Yes, an alibi in jurisdiction. Yeah, yes. Mm-hmm. There's another matter. What is it? I don't know whether you have read the Lamech. Lamech versus
Congo.
Yeah, Congo. Lamech versus the imagine the Lamech. Yeah, Tekla Lamech versus the state. Now imagine here there are 100 witnesses. 100 witnesses. The state calls 20 witnesses. Yeah? The state called 20 witnesses, 20. 20 people come in. How long will that take? 20 witnesses come testify. When witness number 20 come and testify, they want to rely on documents that were seized in terms of the Anti-Corruption Act. Now, the Anti-Corruption Act makes provision for seizure, for information which they get by seizing documents. It also makes provision for information obtained, because the Anti-Corruption Commission Act empowers the director of the anti-corruption to subpoena a person and summon a person to come before him. And so now the anti-corruption, the accused were challenging the propriety and the regularity of the person, of the evidence that has been obtained in terms of the summon, of the person who was summoned. The judge who said, then started discussing the information that was obtained in terms of the seizure. And the judge then comes and make a finding that the documents and this information on seizure was properly obtained and secured. When the documents that relate to seizure were not the ones that were in issue, but the information that was obtained as a result of the summons. So the accused person said, then applied for the judge to recuse himself, because he dealt with issues that were not before him, and they said he has made up his mind already on the documents that were seized. It went to the Supreme Court. The Supreme Court said, yes, set aside, the trial has to start all over again. Yeah, before a new judge, these 20 people who testified must come back again, and all of them must testify. So the whole issue is the prejudice is an actual bias, closure of mind, non-persuasion to a hearing, and where a reasonable person in possession of all the facts forms a reasonable apprehension that there will be a likelihood. Those are the tests. Whenever you are faced with recusal, you do one of those two. If a reasonable person in possession of all the information will form a reasonable apprehension that you're likely to be biased, you must recuse. So all those aspects there, that's what they're dealing with. What they say. So now, on the question of recusal, what is the procedure? The procedure for recusal was discussed in the matter of Opindi versus Magistrate Shilemba. In all these cases, you must look at the ratio. What is the reason for the decision? Now, the Shilemba matter, Opindi versus Shilemba, apart from setting out the principle, it also sets out the procedure that must be followed. Now, what Asino is saying is correct. What happened is, Opindi and another Portuguese guy, Davino or something like that, yeah, were charged with corruption. Now, the state in the trial in the magistrate's court, the state then led its evidence, right? The state led evidence. When the state closed its case, the accused persons in that matter applied for a 174 discharge. The magistrate refused to grant a 174 discharge. When she refused to grant a 174 discharge, they asked for an adjournment. And when they asked for an adjournment, they came back and said, yes, the defense is going to go on its defense, they will testify. But the accused persons themselves will not testify first. They'll call somebody else to testify. So what did the accused do? They called an ex-police officer to come and testify. Now, the ex-police officer came and testified to you see, because the whole charge was that the money to build the swimming pool was not paid by Upindi, but by somebody else who had won. At the time, Upindi was the CEO of Wildlife Resort. So that money was paid by somebody else. You see, as you understand, as a favor for a tender that the person, that was the allegation. So McKay came and the police officer who testified, the ex-police officer, came to testify as to who paid the money, because he said he interviewed the owner of Leak Pool or something like that. And the owner of Leak Pool said, yes, the money was paid by Upindi. He also further testified that there is somebody, I think it was either Upindi's wife or this Ivano's wife, who testified that the magistrate and the prosecutor discussed the matter, and the magistrate conveyed to the prosecutor that they must fix Upindi. Even if it means fabricating evidence to find him guilty, and even if he sits in jail, even if it's just a week or 10 days. This is the evidence that McKay came to give. So the state did not object to that evidence because it's hearsay. The state says the explanation of the state for not objecting to the evidence is that they thought that these people who are being referred to will be called to come and testify. Placed before the magistrate. The magistrate decided to adjourn the proceedings and issue a subpoena in terms of Section 686 of the Criminal Procedure Act, so that she will not recuse herself. These people, the primary sources, because all the others are tertiary and secondary sources. The primary sources of this information, because there are even allegations that the magistrate went and sat in the car. There were APSA deposit slips of $60,000. Now, all those issues are in the judgment. So the magistrate said, all right, if that's the case, I am not going to recuse myself. I want those persons to come and testify. I want to clear my name. Those were I want to clear my name. Those were the words of the magistrate. So they must come and testify. They must be cross-examined and cross-examined. So when she refused, the applicants, because the accused were also seeking stay of prosecution, a number of issues, but in this judgment, I was only worried with and concerned. I've read the other parts, but really not with much attention. I was more concerned with the recusal. They also applied that the decision not to recuse herself, because there are these serious allegations made against her. Therefore, any reasonable-minded person having that information will not see the magistrate giving them Upindi a fair hearing because of all these applications. Those were the basis of the application for the magistrate to recuse herself. The High Court said there was no basis laid and actually refused to set aside and to order the magistrate to recuse herself. The accused unhappy, they appealed to the Supreme Court. Does anyone have Upindi here? I think I had it. Now, in the Upindi matter, the Supreme Court said, first and foremost, one mistake, the first important thing is that the practice and the procedure in recusal application is as follows. When a party, particularly when the procedure is that when a party wants to bring an application for recusal, that party, that legal practitioner, must request a meeting in chambers with a judge or with a presiding officer in the presence of the other party. And they must convey to the presiding officer or to the presiding officer that we intend to bring an application for recusal, and the basis of that application is X, Y, Z in chambers. So that to give the presiding officer an opportunity also to deal with the matters. So, and if the presiding officer decides to recuse herself, that's the end of the matter. But if she doesn't, if she or he doesn't recuse herself, you then bring a formal application on affidavit and under oath, setting out the facts and all the bases. The presiding officer, although the application is against him, in circumstances like that, can put the true fact. And then what this court says, what the Supreme Court says is the presiding officer is only under an obligation to deal with the true facts and answer them. Rumors, unconfirmed evidence are not facts. And once they have placed the facts before, they can then decide and evaluate whether they will recuse or not. But what happened in Opindi versus Shilemba case, what the Supreme Court found is that the procedure was not followed. What happened is the magistrate was literally ambushed. Actually, the Supreme Court used the term, the magistrate herself used the term ambush. The Supreme Court also used the term, it's a trial by ambush, because she didn't know. Secondly, when they were asked whether the defense will bring witnesses, the accused did not, they went out of the normal way where the accused first testify and then supplement. Here they never even disclose. So, and apart from the failure to disclose, the evidence that was placed before the magistrate was inadmissible hearsay evidence. So the court in that case made a distinction, because there was an argument that the hearsay evidence which was presented in the Opindi matter was not to go to prove the truth of what was said, but it was aimed at proving the state of mind of the accused, that they do not, on the basis of the information. So the Supreme Court went into length and said, even when it comes to the admission of this secondary evidence, they categorize it as first-hand, second-hand, and third-hand information. Only, for example, second-hand hearsay information could be admissible instead. But they said in the case of Shilemba, even the evidence that was stated, one of the statements that made allegation of the payment of the 60,000 and the disguise, the person who is alleged to have given this information was said to be an employee, a data typist at the magistrate's court. But they found that that person doesn't exist at all. Secondly, the information was third-hand hearsay evidence. So it was inadmissible. So but what the court says, the reason why the judicial officer, because the judicial officer considered the application for recusal as an affront to herself and her dignity. It's wrong. As a judicial officer, you don't consider recusal application as an affront to yourself where you have to protect yourself. No. It's a question of dealing with justice. But nonetheless, there was no information, proper information placed before court, and therefore, the procedure that was followed was the wrong procedure. So it is on that basis that the application for the magistrate to recuse herself was set aside. Yes, you can by way of an affidavit or just a formal letter. Look at the, what is it, the case of South African Rugby Union. South African Rugby Union. This is the president of South Africa. It's also in the notes there. In that case, the Chief Justice was Justice Charles Carlson in the Constitutional Court. There were other 4 judges. I think Judge Yakub, it's Charles Carlson, Yakub, what is the one armed judge? Nelly, the one armed judge who had, what is the judge's name? Okay, there were 4 judges of the Constitutional Court who were initially, they were members of the African National Congress. You see, the one judge had even lost his arm because during the struggle, the agencies of the South African Army sent him a parcel bomb. His first wife actually died in the bomb, and then he lost his arm from the parcel bomb. So these judges were all constitutional, and they were appointed by, and Justice Charles Carlson was even also the best man at one of the weddings of Mandela's daughters. Or was even if he was not best man, he was a special guest at the wedding. So the president of the South African Rugby Union, when the matter was to be heard in the Constitutional Court, asked for these 4 judges to recuse themselves because they'll be obedient and lenient to the president and because of the ties. Now, what happened in those cases, Justice Charles Carlson answered to all these allegations, not in an affidavit, but in a letter saying, these are the correct facts. Yes, I attended Madiba's son's wedding. I was a special guest, but that's where it ended. The other members also wrote affidavit. Yes, we're members of the African National Congress. So it all depends on how you deal with it. In this case, they did not do it by affidavits, but they were clear letters. And then they said, because of their training, and particularly in the light of the Constitutional Court, they formed the opinion that they are open to persuasion and they are properly, and a reasonable person having the facts as stated by Justice Charles Carlson, and the facts will not form an opinion that the court will not be impartial. And the application for recusal was dismissed on that basis in the South African Rugby Union case. I was sitting in the matter. And then the lawyers kept on, yes, if that's the way you go, we are going to appeal. We are going to appeal. No. You see, all that, remember, as a judicial officer, I must confess, I'll give you one example where I lost my cool and I behaved unjudicially. But in a case like this, all that I say, I stopped the proceeding and said, and you talk to them in a cool, calculated manner. You see what? The issue of appeal, it's your right. Remember, the Constitution guarantees you the right for your dispute to be adjudicated, but you don't have to threaten me, because your threats are tantamount to an influence, an indirect influence of trying to influence me to come to a given. And if you proceed on that, I might cite you for contempt. Yeah, if they proceed, you may, you see, because when a legal practitioner keeps on threatening you with appeal, they're actually trying to coerce you to decide in a given way, and that is improper. And such conduct, you can even report it to the Law Society. Then they can.
Yeah, they do that.
Yes. All right. Before we, okay. How many? I've given you about 6 or 7 Namibian cases. The only one that, but it's in there. The other one that I saw quite a number of them. There's another one of is it what is it? Kaveongelwa? Kaveongelwa versus, yeah, versus Ndaitunga. Yeah. So if you read, please read, what I'm going to say, it's not only a question of reading. Study the cases that I've given on recusal. There is one case, but it's quite long. It's 89 pages. It's the case of Biekes. It's Biekes versus, is it Christian? Oh, funny. Before Justice Gaia. It's a very, very long, it's 89 pages. You read and you fall asleep while you are reading it, or you read it in 2 days. But what I'm saying is, Munuma, Upindi, and SNS, those 3 cases in my view, and actually in Ndaitunga to an extent, but Munuma, Upindi, and S, those 3 cases actually succinctly summarizes and set out the law on recusal in our jurisdiction. With that article that I have, it's an article that has been Justice O'Regan and Justice Cameron. Now, okay, on the lighter side now. Was I doing motion court or was it? I think it was motion court. Motion court is every Friday you have this unopposed matters. So my role was full. I think that day I even had 2 counsel, senior counsel from South Africa, because I was at the time when I was dealing with the tender, the airport tender case. So, no, it was a case management. It was in case management. So I called the matters. Call one matter, and then one of the legal practitioners in the matter that I called actually had given a notice for intention to amend. But what they did is they just filed a notice of amendment. So I asked the legal practitioner, now, when you file an amendment, because what I normally do with legal practice, I just don't tell them what is wrong. I said, what is the rule that governs amendments? At that time, it was Rule 18. No, it's Rule 18. Now, what does Rule 18 say? No, Rule 18 says, when you want to amend, you give notice to the other party that you intend to amend, and you give them 10 days within they signify whether they will oppose the amendment or not. If they don't give notice, because in the notice to amend you set out the amendment. If they don't oppose, then the amendment is deemed to have been effected. If they oppose, then you must set down the application for amendment for a hearing, and then you adjudicate. Now, this legal practitioner had just filed an amendment. So I asked him, he didn't do all this. So I said, now, on what basis are you asking me to grant the amendment? Yeah, the other parties are not here. I said, but you haven't given notice? Whether the parties, one thing I said to lawyer, and I do this a lot in default judgment, the fact that the other party doesn't oppose, although it's no defense, does not mean I must grant you what you're asking. You need to make out your case. If you haven't made out your case, even if there's nobody on the other side, I'm not going to give it to you. So I said to them, you haven't followed the rules, you haven't given notice, you haven't given the party an opportunity to decide whether they will oppose the amendment or not. So I struck the matter from the road. So there was an in-person litigant. Meanwhile, unbeknown to me, this in-person litigant, they have formed the view that I am apparently a booty for the white lawyers. I scandalize black lawyers. I treat them with disregard. That's his perception. So his case got called. As soon as his case is called, I said, yes. He said, yeah, you. I said, yeah, he says, you. I said, what? Are you speaking to me? He says, yes, I'm speaking to you. I have a problem with you. Oh, you have a problem with me. I'm not party to your proceedings. What problem? Yeah, you are such a incompetent, useless. You don't even know. No, in court, in open court. You don't even know how to handle a simple application for amendment. I said, are you speaking to me? He says, I'm speaking to you, pointing a finger at me. Yay. The gasket blasted. So I said to the court orderly, please remove that person from my court. I do not want to deal with them. So, unfortunately, the court orderly on that day was a poor, tiny, little woman. She get to the guy, it's Biegas. She gets to the guy, and he says, hey, Vampufru, je raakt me niet aan. Je raakt me niet aan. Hey, you don't touch him. So I said, court orderly, go and sit. And so he wanted to go out. I said, Mr. Biegas, come back, and stand. So I said to him, Biegas, you must know one thing. I've never been a coward in my life. The fact that I'm sitting, you are taking advantage. I'm sitting here in these black clothes, and you know I can't do anything. But remember, I come from the same ghetto, Katutura, you are coming from. I grew up there. I know how to handle a knife, and I know how to handle a fist. Yes. If it comes to that, I'm prepared to take out these black clothes, and we meet in the street and deal with each other. No, it's true. This is what has. So, and then he left. He said, "Look, he's even a scholar. He wants to fight." No, then I said, is it only now then when I'm saying that you are realizing that I'm a scholar? When you were doing it, you didn't realize. I love man. So they even reported it to the Judicial Service Commission. What I did is I didn't write a report. I only had the whole proceedings transcribed and put it before them. But I wouldn't advise anybody to lose his school like. I regret, but I'm not sorry. Yes, yeah. So that's a light hand. You will find.
That was contempt in Fashe.
That's contempt in Fakikuri.
And everything was recorded.
Yes.
Are you not allowed in your procedure to proceed with a summary decision because the evidence is there and the witnesses?
We will deal with it. We'll deal with it very briefly. Now, let me give two other. One of them was your colleague. He's no longer your colleague. D-Court, Mungunda. I'm in court as a legal practitioner. I'm representing somebody else. Opa Brett. Guy stands there. Accused. Yes, Your Worship. These are the charges you face. And then the accused said, aye, it's a woman, some mass man. Opa Brett, the magistrate says, what is he saying? Interpreter, what is he saying? No, I can't interpret. It's a miba man now, but mass man. The accused say, man, prosecutor, don't be scared. Tell the man I'm saying his mother, man. What does Oberbrett do? You know, what is even, I was in court. At that time, I was the deputy chairperson of the Magistrates Commission. What does Oberbrett do? He switches off the machine. Oh, my work, man. those are some, so don't get, those are the bad examples of judicial officer. So, but if you study, especially the Supreme Court decision on recusal, there is no way you can answer. I've forwarded 3 questions to the judge president, which will be included. He'll choose which one he'll include. But they are not part, I'm not lying to you. They are not part. Yeah, they are not part of this one. No, because I told you I have 15 years of teaching experience. You will tell students that I don't give a scope, or that the scope is this, and then you come and ask something else. No, I don't do those things. Yes. Now, contempt of court. This is the last topic. I'll just quickly run through them. Now, what is contempt of court? What they're saying, there is a definition. And the definition is contained in a South African case of FACI and versus CCI systems. I'll get all those cases and the citation. For contempt, I'll give you most like at the maximum 4 cases. Of the 3 questions that I gave to the judge president, that no, I haven't yet given them. I'm planning to give them after this. 2 of them deal with recusal. 1 of them is on contempt. And the one that is on contempt is on ex facie curiae contempt, not in curia, because with the in curia one is straightforward. Now, contempt is defined as an injury committed against a person or a body occupying a public judicial office, by which injury to the dignity and respect which is due to such office or its authority in the administration of justice is intentionally violated. Okay, what I'm saying is, I'm going to refer, to give you the case where this is said. It's contempt is defined as an injury committed against a person or a body occupying a public office, a public judicial office, not only a public office, but a public judicial office, by which injury the dignity and respect which is due to such office or its authority in the administration of justice is intentionally violated. Now, just like as I said, when a sitting judge or a magistrate, you start insulting him, the evidence, as Lorraine said, that is what we call contempt in facie curia. Now, the example that Velikoshi has given us, where although this may not be contempt, but it may be an attempt to influence the court to come to a specific. But what the authorities are saying, contempt in curia, in facie curia, can also take place, although not in the court itself, but if it's in the precinct of the court. And for example, the lawyers stand outside and say, they move van a judge of they move van a magistrate. He's so slack, he's so corrupt. You understand? And they speak as loud that whilst you are in court, you can hear it. It can also be regarded as contempt in facie curiae. Now, with contempt in facie curiae, it's only up to now, before 1990, you could deal with it summarily. That you call, the evidence is there. As a judicial officer in whose presence the contempt has been, you see, because it's an injury against the person or the body occupying a public office. That evidence is there. Now remember, at common law and before 1990, you could deal with that person. Today, it's not so clear, I must say. Why do I say it's not so clear whether you can deal with it as either a judicial officer? Article 12 of the Constitution says no person shall be found guilty without a fair hearing. Now, the whole content of a fair hearing is that everybody is entitled to be given notice of the charges which they face, to be given time to prepare for the charges, and to be legally represented. So I cannot, with a clear conviction, tell you whether you can today, under the current constitutional dispensation, invoke summary citation of the party. I doubt. You see, because the Constitution guarantees that person a right to be notified of the charges they face. They are guaranteed time to prepare, and they are guaranteed the right of legal representation. You see, you know what they say. I have read. I can't recall the judgment, where they said the right to a fair hearing that has been guaranteed in the Constitution is equated to the situation when God found Eve giving Adam the prohibited apple. He just also did not proceed to sentence her. He gave her and Adam an opportunity to defend himself. Adam says, "It's the wife you gave me." So he had the opportunity. So what the literature and the thinking is, because especially in Fakicuria, is of a criminal nature, the person must be informed of the charge that they are facing. They must be given an opportunity to prepare and defend themselves, and they must be given an opportunity. So you see, where I am on most confident that a summary trial and sanctioning will fall is on the basis of an opportunity to defend yourself. And if, for example, they are also not even legally represented, that I had no legal representation. So on those bases, I am almost confident that, yes, a summary trial of an Fakicuria where it doesn't give the accused party an opportunity to notice of the charges. Okay, you get the notice of the charges that you have injured the person of the judicial officer or the court. But did you give him time to prepare in his defense? Did you give him an opportunity to be represented by a legal practitioner of their choice? Those are the issues that will render the trial and the conviction most likely unconstitutional. The fight for justice, the fight for independence was just not freedom. It was for justice, equality, and fairness for all, irrespective of the race. So we knew that what was happening was unjust, was unfair, and was discriminatory. So now we have arrived at a place where we say justice for all, fairness for all, and equality for all. I appreciate and have, you see, this is one thing I appreciate about law. I appreciate about law. It inculcates into you the sense of justice. In how much, as it has had. You see, you ask yourself, you look at, I take a guy like Yatoivo. They went to World War. They fought. They were victorious against the Germans. What did they get? Bicycles. And the white soldiers, what did they get? Farms and wealth. But we are saying we are fighting. Those are the issues that drove us to fight, so that we can have justice, equality, and fairness for all. So wherever where you are, you and I don't know, I must say we are in a fortunate situation that we have come at a historic level where we are saying, and we are committing ourselves, and this comes from the preamble, we the people of Namibia have decided to form for ourselves a republic that will be governed and based on the rule of law and justice for all. Tough luck. That is what we have decided we want to go, and we must live and walk that talk.
What brought that interest was just the time.
Yes, okay. Now then, that's the ex facie curiae, what is it, contempt. Contempt in ex facie curiae, that's outside the court. Contempt outside the court can take place in 2 or 3 bases. One, it's where you disobey a court order. Now, where a court order is disobeyed, there's Maletsky versus Standard Bank. It's a case of Maletsky. It was delivered on the, I think, in Maletsky versus Standard Bank, what happened is Maletsky had taken a loan from a bank. So he then was just not paying. When he wasn't paying, the bank sued him for the money. Judgment was granted against it. He was ordered to pay the money. He wouldn't. Now, at the time that the case against Maletsky, it's prior to the current rules. The current rules actually determine that before you declare a person's home executable, actually I'm sitting with a case where I have, no, it's not yours. Not Augusto. Hiskia. It's a case emanating from the magistrate court where there is a challenge to the constitutionality of Rule 65. Rule 65 is those financial inquiries, and where clerks of court issue default judgments. I'm going to write a judgment very soon on those bases. But let's come back. Maletsky was then held for a financial inquiry in terms of Rule 45 of the High Court rules. So when he was held, he was told to come to court on a specific date. I think it was the 27th of September 2012, that he had to bring his payslip for the previous year, his whole financial statement, the bank statements for the previous year. On the 27th of October, Maletsky just didn't turn up. He just decided he's not turning up. So the other party, the bank, then instituted civil contempt proceedings. That there is a court order. He has refused. Now, in the Maletsky case, this issue doesn't come out very quietly. But in the case, the Faki case, the Faki or NO case, the issue comes out quite clear. So in the Maletsky's case, the court found that he's in contempt. But in the Faki case, the issues that came up is, what is the standard of proof that one has? How do you prove that the person is in contempt? The Maletsky case simply tells us you must be able to prove that there is a court order, that the court order was served on the person. If it was not served on him, that he has received it and has ignored it. Right? Now, in the South African case, the debate was, what is the standard? Is it for you to be able to find that the person is, the Faki case came to the conclusion that, you see, because they were saying, although it's civil contempt, imprisonment and sanction, it's a criminal it's a criminal sanction that comes into play. Do you then prove the contempt on a balance of probability or of beyond reasonable doubt? What do we think? You see, what I'm saying is the Maletsky case simply says there must be proof that there was a court order, that the court order was served, and that the court order was not complied with. That's what Maletsky. Then it's sufficient to find a person guilty. The facts of the Faki case was that what happened is there was a tender in South Africa. There was a tender for the procurement of arms and ammunition. Now, complaints then came about that the award of the tender was irregularly granted. Now, when the complaints came, I think the president at the time was still Thabo Mbeki. The president set up a commission of inquiry, and the commission consisted of the Auditor General and quite a number of issues. So the Auditor General then, they set up this committee, they made a report and findings. So when they made a report and the findings, they provided the report to the office of the president and to parliament, clearing the tender of all irregularities. The company that was successful the company that was unsuccessful in the tender then requested the documents and report from the Auditor General on which the report was based. The Auditor General refused to grant the documents. They brought an application to the High Court to compel the Auditor General to release the documents. The High Court of North Gauteng then ordered the Auditor General to release the documents. They did not release the documents for a period of 40 days. So this person, the company then brought proceedings for contempt of court against the Auditor General. The Auditor General was then found, you see, all that the High Court said, the High Court, the North Gauteng High Court asked, was there a court order, was it served, and was it obeyed? And all the answers were in the affirmative. There was a court, it was a court order, it was served, and it wasn't complied with. So the Auditor General was found to be guilty of contempt of court, and she was then sentenced to 9 months imprisonment. But by the time the appeal went to the Supreme Court of Appeal, the Auditor General had released some of the reports, most of the documents. So at the Supreme Court, the argument was that the test that the High Court applied is the test on a balance of probability, which carries, but because even though it is a civil contempt, the test must be the person must prove beyond reasonable doubt. And therefore, when you have to go beyond reasonable doubt, you must prove the intention to disregard. It's not only that the court order has not been obeyed, but you must prove the intention of the party to disregard the court order. Now, okay, in the Faki case, the argument that you are advancing was also, but now, then Justice Cameron, who delivered the judgment, referred to a constitutional provision, the equivalent of which is our Article 78, sub-Article 3, which says, no member of the cabinet or the legislature or any other person shall interfere with the judges or judicial officers in their exercise of judicial, and all organs of the state shall accord such assistance to courts as may require to protect their independence, dignity, effectiveness, subject to the terms of this Constitution. So what Justice Cameron has actually said in the fucking matter is that the whole crime of offense of contempt has been constitutionalized because there is a constitutional prohibition of people to disregard and to interfere with the court. So when a court makes it, and that the state must render all the necessary assistance to the judiciary to be effective. So if court orders are disobeyed, then you can as well close the court doors. So that's the argument that Justice Cameron went about and said, even though the civil contempt of court is of a civil nature, for you to be able to prove contempt, you must prove that there was a court order, that the court order has been served on the person who's concerned, and that the court order has not been obeyed. And apart from that the court order has not been, you must also be able to prove the intention that this person has the intention not to obey the court order. And you do all those facts must be proven beyond reasonable doubt. That's the current position. In our case, it has not, in Namibia, it has not yet been decided. Another case, another issue that contempt ex facie curiae, contempt ex facie curiae, is what is termed as scandalizing the court. Now, one of the best cases that I found with scandalizing the court emanates from Zimbabwe. It's a case of Ueitele Recusal. Now, the facts of that case are briefly like this. There were American citizens who were found with revolvers, machine guns, which they were attempting to board on an aeroplane parked at the Harare International Airport. So they were then arrested. I think they were arrested in March. Their trial started running from August to September. They were then found guilty. When they were found guilty, what the High Court did is gave them sentences of about 6 months imprisonment and suspended some of them. Patrick Chinamaza, at the time, was the Attorney General. What he then did is he went to the newspapers and said, the conviction, he's made quite a number of statements. And as soon as he made the statements, the court, the judge who presided over the matter, cited him for contempt of court, that he is scandalizing the court. And Patrick Chinamaza raised quite a number of points of law. The first one, whether the offense, the civil contempt ex facie curiae, is still an offense under our common law, where the scandalization of the court. Now, that compares with the constitutional right to freedom of speech. So there it was argued that he is just expressing his freedom of speech, he's expressing himself. The court says, although there is a fine line of definition between genuine criticism, that can still be taken. But when you are trying to injure the person of the judge and the person of the public office of the judiciary, that is scandalizing the court, and that offense still is part of our common Roman Dutch law. And again, the test that the Chinamaza matter raised is, you must be able to prove beyond on the basis that he was just expressing an opinion and he did not have the intention to scandalize the court. He was found not guilty. So now, under our current rules, particularly with civil contempt, how do we bring civil contempt? The civil contempt procedure, I think it's Rule 74. Oh, Okay, I see. I have the. But really, these cases don't. I'll ask Ms. Klute. It's the case of the Minister of Education versus Commerce. It's also that's ex facie curiae contempt. Maletsky, I have the cases that I forgot to give. So she'll make copies for us. But the procedure is, I think, Rule 74. You know, I'm using the term. Why do I raise the procedure? Because we have applications, right? Maybe you dealt with applications. There is normal application, opposed motions. That's Rule 65. You have review applications. That's Rule 73. You have election applications. I think it's Rule 79. But contempt application, you bring them in terms of rules, particularly civil contempt application, is in terms of Rule 74. Now, Rule 74 says you must issue a notice of motion directed to the person against whom the proceedings are sought to be brought, and the application must be supported by an affidavit. And in the affidavit, you set out the grounds on which the allegation for contempt are based. So in a nutshell, that's it. It's a good question. Who drafts the affidavit? The affidavit, remember, it's of the person who alleges that the other person has committed a contempt. But the practice is, you see, as an ordinary person, I go to a lawyer, I consult with him, and the lawyer drafts the affidavit. But I am the one signing the affidavit. So if you are a party, you have an order in your favor. As a judge, you draft. Yeah. There is a case of Justice Guy. The one I said is 89 pages. Yes. What happened in that case, Justice Gaia had to preside. It's a matter in Rehoboth. So these guys came and say, Justice Gaia is a German. The Germans came and stole the land in this country. He's just as corrupt as his forefathers, and he is not capable of presiding over the matter. So he asked them. He found them to be because they made this statement in court. They didn't even make an affidavit. Bjerges just stood up in court and says, "You are a German. Your forefathers came and killed our people. You are not qualified to preside over us." And all those allegations, he made them in court. So Justice Gaia found them to be in contempt, in facie curiae. But what he did is he referred the matter to the prosecutor general. He made an affidavit and a statement of what has happened. He had the proceedings transcribed and forwarded them to the prosecutor general for the prosecutor general to institute criminal proceedings in respect of contempt of court. So this is why I said, under the current constitutional dispensation, when contempt has been committed in court, my take is, as the judicial officer, you make a statement, you transcribe the best is to have the proceeding transcribed. With a statement, you hand them over to the prosecutor, for the prosecutor general to summon that party and to charge them with contempt of court proceedings. That's my take. But for you see, in the past, like I said, before independence, you tell a magistrate, Yoma, we said, accused, come here. You are insulting the court, found guilty of contempt in court, sentence you to 5 years imprisonment. Stay, full stop. And it will be valid and legal. Go ahead. But today, I doubt whether you'll ever be able to do such a thing. Because this is what I'm saying. With review, I'm very careful to rely on review matters. Because all that the review court does it I remember when I was sitting on reviews, you see, were the proceedings in accordance with the law? That's what you look at on review. It's only when the proceedings are not in accordance with the law that when you raise a query and then you send it to the magistrate, depending on the answer by the magistrate, that's when you write a judgment. But if some of the proceedings, the irregularity, are not apparent from the record, it's difficult to rely on review judgments. Remember, Article 140 of the Constitution says, all the laws that were valid and enforced at the date of independence remain to be valid and enforced until they are repealed or they are declared unconstitutional by a competent court. Unfortunately, magistrates' courts do not have the competency to declare statute unconstitutional. So as a magistrate, even if you are 220% convinced that the statute is unconstitutional, you have no choice but you are bound by it. But then you can raise it, and the court on review or on appeal can then go into the constitutionality of the matter. So if it's a statute at a high court level, if you doubt the constitutionality, what you then do, the court can raise the constitutionality of a statute mero moto on its own. But what you do when you raise as a court, as a high court, when you raise the constitution, you must then adjourn the proceedings. You must ask the Attorney General to be joined so that they can argue the matter of the Constitution. Because at the end of the day, in terms of Article 25, once you find a statute to be unconstitutional, there are quite a number of remedies that you can embark. You must ask Parliament to rectify the unconstitutionality. You give them time within which. So and the principal legal advisor for government is the Attorney General. If he was not part of the proceedings, how can you order him to do something? So he must be part of the proceedings. He must be cited for you to decide on the constitutionality of any statute. The Attorney General must be a party. If the Attorney General is not a party, you cannot decide on the constitutionality of a statute. I'm talking of a scenario. Let's take, for example, the scenario that I'm taking is Rule 65 of the Magistrates Court Act. Rule 65 of the Magistrates Court empowers the clerk of court to grant default judgment. Now, Article 78 of the Namibian Constitution says the judicial power of Namibia vests in the judiciary, the courts, which constitutes the Supreme Court, the High Court, and the lower courts. Now, if you are not a judicial officer, you cannot grant judgment. You understand? So, but currently it's proceeding because that statute, and because of Article 140, which says every law that was enforced at the time of continue to be enforced until set aside or repealed. It has not been set aside, it has not been repealed, so it's continuing. So that is the scenario I was looking at. But where it's the interpretation of an act, it's a different ballgame, because what you are conveying to me, my understanding of what you are saying, is the interpretation of the breadth and width of Section 112 of the Criminal Procedure Act. But its constitutionality is not in issue. Yes. Mm-hmm. That's a different question from the one that I dealt with. You see, for you to be able to prove ex facie curia, there is one, the disobeying. With the disobeying of a court order, there must be three elements. With the disobeying. Remember, ex facie curia contempt is committed either by disobeying or by scandalizing the court. It's one of the two. So when it comes to disobeying, the person must prove that, one, there was a court order. Two, the court order was served or came to the knowledge of the person. And 3, the court order was not disobeyed, and it was not disobeyed with a intent, with a careful, with a established intent. Yes, those are the 3 elements that I refer to. All right. That's the end of the day.